But see, look at this judge. This is a stern-looking man.
No bow tie on this guy.
Nope. His tie goes all the way to the floor, anchors him in place, holds him to his principles of justice.
Say jury nullification one more time. I dare you.
All right, I'm going to take a short 10-minute break for the jury.
See you, Runkle.
The jury can follow my bailiffs out. Everybody else can remain seated. 10 minutes.
I like this guy's speed. It's nice.
Yeah.
The judge?
Yeah, especially after Mommy Chew, this is like a very nice tempo change.
Yeah, and he's told both counsel a couple times in this case so far, you got like one or two questions and get done. Get done with this. This is, he doesn't have any qualms about telling the attorneys to move on because they're wasting time.
That's good.
Yeah, absolutely should.
I'm going to object to this at this point because just watching the video again and again and again, he should be asked about what he saw.
I agree. Sustained. We can play the video, though it's been played now at least 25 times. Play with this witness for another one or two questions, then we're going to move on.
Mr. Parr, you indicated that you initially didn't see Mr. Clearman.
Blood alcohol concentration estimation chart.
Okay, I'm going to show you what's marked as Exhibit D18. Dr. Kelly, you recognize this document?
Objection, Your Honor. We've just gone through this. We're literally just going through the same thing again with another witness.
He's going to ask him.
Where are we going with this? Is this the exact same exhibit that was shown to the last witness?
Right, but it is. But Judge, he's saying that he's familiar with those things. I'm asking him to confirm if that comports with his knowledge of that.
What's the relevance? We've already gotten in it.
Number one, this is automatically admissible under Wisconsin law.
I don't want to talk about admissibility. I think the objection was cumulative. If we just heard one witness expound on alcohol and BAC and all those things, why do we need this witness to do that?
I'm not going to have him go into that. I just want to be able to see.
Really?
Recognize the chart and
bullshit.
Right, he can answer if he recognizes the chart, then let's ask questions that are not cumulative or repetitive.
Bullshit, you're not here to ask cumulative questions. Yeah. You are a liar, sir.
Yeah.
You said you recognize the chart. Can you tell us what
he's now desperately in his head in real time trying to reformulate his clearly cumulative questions into something that approaches a non-cumulative fashion. That's what's happening right now.
Yep, that's right.
He was going to ask
the judge
this
is going
guy
to call bullshit in about 45 seconds.
He was going to ask the exact same questions to this guy as he did to the last lady.
Watch the state throw their hands up.
Just get a timer out.
You're out and
Are we serious?
You look up the chart for your sex.
Your Honor, this sounds really familiar, Your Honor. Yep, there it is.
Sidebar.
Kurt,
I'm sorry,
Kurt,
I said 45
timer.
seconds. What I meant to say was more like 25, but it's not hard to predict the future when you've seen the story before.
Okay, so what's going on? We haven't gotten to hear a lot of sidebars, but let me tell you what's happening right when these guys get in. Counsel, what the hell is this? Tell me your line of questionings right now. Right now, tell me your line of questioning. I told you this cannot be cumulative. I told you I want this done this morning. I told you you're wasting the court's time. Tell me right now, what line of questioning are you going to get to outside of the blood alcohol content? What are your questions? Tell me right now. If you don't have them, he's done. You're done. Sit down, call your next witness.
Did you hear a few years ago this judge had a public defender arrested for contempt in the courtroom, dragged out of the courtroom, and when they brought him back in, they were shackled, not because the judge ordered that, but because it was SOP when the court takes someone. So the public defender comes back in the court and they've got a waist shackles on.
Here you have her talking to him, asking him, right?
Well,
is that what we just heard?
Yes, but
okay. Thank you.
Yes.
Now,
thank you. Be quiet now.
And this is cross. You'll get a chance to follow up.
Now, she's
Mr. Lamar, knock off the insulting behavior towards the court. Knock it off.
Ma'am,
shut your mouth.
She's talking. She's trying to address her dead husband. He's not responding. He's gone, right?
Oh, another sidebar.
Oh, God.
We're gonna hear like 3 gunshots, and the judge is gonna come out by himself with a smoking pistol in hand.
Remaining counsel proceed.
Case dismissed.
Don't you?
Yes.
All right. Do you recall Ashley Sheldon reaching out to you? Ashley, would you please stand up?
She didn't reach out to me. She just came up to my place of work.
She came up to your place of work.
And she said she was in Milwaukee Police Department.
She said she was the
She said she was with the police.
Okay.
Oh my god.
Sidebar. Oh shit, you idiot. Did your assistant go and represent that she was a member of the police?
Oh boy. Oh boy.
Oh God, this is not the day could go better for the defense.
All right, we're going to take a break. I want to discuss that sidebar.
Uh-oh.
I call it an immediate sidebar because the testimony that was just elicited by the defense was that their own investigator allegedly told the witness that she was a police officer, which would first of all be false. Secondly, be dangerous in terms of the presentation of this case. Who wants to explain that? Beyond that, for the defense, that potentially makes your assistant or investigator a witness. Your side, Mr. Ahmad, just elicited testimony and making it a big deal over who that witness spoke to and didn't speak to. Mr. Lamar said, you didn't come and talk to us, did you? And then when the state followed up on cross, the witness, who's a lay witness who has no interest in this case whatsoever, said your investigator or your assistant who's sitting at the table right now, a blonde female, came and represented herself as a police officer.
Put her on the stand.
No, I want to hear from them first.
Firm maybe trying to get some civil lawsuit that might be doing some investigation. He told me it had nothing to do with him. We knew it wasn't the Milwaukee Police Department. And then when defense counsel says, well, you never met with us, that would obviously include someone sitting at their table that they didn't meet with. So I was left in the impression it was someone completely different. I wasn't expecting them to then point out their own paralegal. And then that was unfortunately the answer that we got. So that is the factual basis of how I came aware of it. And I let defense counsel know that whoever talked to him left him with the distinct impression, based on how they introduced themselves, that he was speaking to a Milwaukee police detective.
None of that alleviates my concern. No one that's not an attorney.
I love this judge.
No one that's not an attorney speaks in this court.
Mr. Ahmad, that does not relieve any of my concern. Everything the state just said heightens my concern.
Yes.
This was discussed. Now this comes in as a surprise. Your paralegal was just potentially made a witness in this case. And as you know, I'm not saying this occurred, but if it did occur, impersonating a police officer is a felony. Okay? This is not a good situation. And I want an explanation right now from the defense.
Judge, as I explained in chambers, so Attorney Huebner had contacted me a couple weeks ago. We were discussing some witnesses, and then he brought this up regarding Mr.
She better be
Parr.
nervous as
At
shit
that
because
moment,
her
Ms.
firm will
Sheldon
probably
was in
defend her,
my
and that means she's
office,
guilty.
And I had her come in and we spoke together, all three of us. It was on speakerphone with Attorney Huebner. I told her no. She did reach out to Mr. Parr. I believe she had a brief conversation with him at work. She gave our own business card. We wanted to meet with him to come into our office. I don't think there was any follow-up. But Ms. Sheldon works with me and Attorney Nolan and Attorney Lynn, who all practice here in Milwaukee. We always identify ourselves as a modern assessment.
Then the problem is you asked a specifically misleading question to the witness because you and your co-counsel know, based on what you just said, that your investigator spoke with that witness, and yet Mr. Lamar led the witness into saying, well, you didn't speak to our firm, did you? Yes, that's exactly what was said.
They're not getting out of this one.
Because Mr. Lamar was trying to imply bias in that witness because he spoke to the state and not your firm. Yep. Exactly what Mr. Lamar asked was, well, you didn't come speak to us. Counsel, that's a problem.
Plan on making Ms. Sheldon a witness. We wanted to move on.
The state may want to call her as a witness now.
Yeah.
Attorney Huebner?
Hubner just wants this to
There
go
are two
away.
firms involved,
Yeah.
Attorney Lamar's firm and then our firm.
But Mr. Matas, you're a
Oh,
team.
stop that.
He
Stop
believes
that shit
that-
right
Okay,
now.
that's like the head coach telling me he didn't know that the assistant coach was calling a timeout or vice versa. Doesn't work
Yeah.
that way. Taking a break.
I like this. This judge is great.
That's almost certainly
He's
what
badass.
happened. Yeah, that's almost certainly what happened. I mean, the defense just fucked up.
Yeah.
But it's not excusable or acceptable. That's what the judge is really saying here.
He's making it clear.
And by the way, so that firm distinction that the lawyer tried to pull right there, when two law firms are working together on a particular case, they're sharing a file, they're sharing information, they're pretty much regarded as a firm under the rules of professional conduct.
Yes.
Even if you have two lawyers who are not associated working in the same building, they're considered the same firm unless they're specifically like separated out on issues. So that's why I was like, don't try that shit. You don't get to weasel your way out by saying, oh, well, we're actually two different firms. No, you're on the same file. You're hired for the same defense. You're one firm for the purposes of professional conduct. And that was a very, very bad look by the defense.
They looked incompetent.
Very.
Probably because they were incompetent.
Yeah, sorry, we had absolutely no idea what people in our office were doing, and that's why we asked these questions.
Yeah. And I asked the question, and the judge is 100% right. You're trying to elicit bias, and yet you knew that you had reached out to him, so you asked a misleading question. That goes to candor before the court. There are multiple professional responsibility violations that potentially occurred in the past 10 minutes from that one firm. And here's just a pro tip for everybody. Maybe don't request the judge be recused as a racist right before the trial and then expect to get anything less than the treatment they're getting in trial. It's not going to be the best look. So this judge seems to have no time for bullshittery, which is good. He shouldn't. The one of the reasons I wanted to watch this case is because it has all of the potential to become a circus based on the defense being Mr. B. Ivory Lamar appears to be an activist, and an activist attorney with a judge in a race-related case it could just explode into nonsense and mayhem at any moment. And this judge doesn't want it.
This is the perfect judge for that.
Yes.
Because he's a guy who's not going to take BS. He doesn't take crap. He sees through the games. He calls you on your BS.
On direct, Ms. Clearman just opened the door as to the peacefulness of Mr. Clearman. The relevance of the Facebook post show otherwise.
The Facebook posts don't show anything. First of all, counsel, start by identifying them.
Your Honor, it is the screenshot of Ms.
He's pissed. Look at his hand shaking.
And who got these screenshots?
It's publicly available online.
Who got
Tell
them?
me who got the screenshots?
We got the screenshots.
Who?
Authenticate
Stop
it.
saying we. Who?
The defense counsel, the paralegal Ashley just printed them out just a couple minutes.
Ashley who? Then again, Ashley is a witness in this case.
Yep.
Step out for the rest of this trial. Sidebar.
Oh,
What are you doing? You're going to just have your paralegal grab some screenshots of a thing. You're going to have her authenticate it. What was the date that the screenshot came out? Have they been altered? The prosecutor gets to cross-examine her. You're going to have to lay foundation. Why does she know these screenshots to be fair and accurate representations? I mean,
she found them on the internet. Ooh, yeah. Come on.
Is this the same paralegal who was the purported cop?
That's who was out of the courtroom. Yeah.
I mean, she could well have been a witness on that basis alone. Now she's another witness. She's going out and collecting evidence.
Haha, I just got your paralegal thrown out of the courtroom. Haha, get wrecked.
That shows the name Jason Clearman. We probably won't get along is the exact language of that. And there's
which goes to show he's violent.
Now,
you
as
did
far
that.
As authentication, I think
you
we
did
could
that.
simply just
That's what
ask
you're getting
her,
your paralegal thrown
and
out
we don't
over.
need to show this to the jury. We can say, is this a fair and accurate representation of his Facebook profile? If she says no, then that's the end. We're not going to try to rebut that, and the jury doesn't need to see what it is. But if she says yes, then she can confirm that is what is tagline was, and that's pretty much it.
His
It's not
tagline
really,
on
we're
his
not going to
Facebook-
show it on the.
Of course
There
it
are
doesn't.
plenty of people
Nothing.
that I don't get along with that have never punched me or shot me in the face.
Nor would I.
Probably won't get along. It's
Right, the one Facebook post, it looks like it might be,
We probably won't get along has nothing to do with the character for unpeacefulness. What are you talking about?
I don't know how to describe it because as far as I'm concerned, Facebook is part of the downfall of society.
Nice. Oh my God, I love him.
And I'm not on Facebook, thankfully, but it looks like it might be possibly a screenshot. One that says, Jason Clearman, we probably won't get along. Then there's one that says, Evangelina Clearman, I, however, do get along with him. That's relevant how?
in terms of peacefulness. If you're somebody who just doesn't get along with others,
Oh my
You're
God, what a
problem with them.
reach.
the proposition that Mr. Clearman is putting on his own page, then
This is it? This is what they have?
it's to
Yep.
his peacefulness, or I think that's a jury question to decide, Judge, if he's a peaceful character or unpeaceful character. We've seen the video, so we're aware. Of some
This is
of
a Binger argument.
the facts in this case.
Hey, no threshold required. Just put it in front of the jury, whatever it is. Let them decide.
I think that
This is
since it's been introduced, I think it's fair game, Judge. If it wasn't, then I think the state.
But
would have
this
a much
isn't
stronger
probative
argument to
evidence.
pursue this.
I disagree.
You can't even look at the
it's
judge as he's
character.
arguing it. He's looking
Screenshot
away
of
from the
one
judge.
Facebook post shows nothing.
The way he sounds like he can't be bothered with everything, but I do like the way he's very direct and he makes decisions and he's very sort of like, yeah,
Oh,
he's always in don't be brazen with me mode.
his hand was shaking. I mean,
Yeah.
it was shaking grabbing that paper. He is on edge with this defense. They have angered this judge tremendously.
What is
throughout
rule
the
number
trial.
1 of litigation?
Don't piss off the
Don't
judge.
piss off
Don't
judge, man.
piss off the judge.
I wonder what's going through that defendant's head.
He came out and the other lawyers didn't. Are they dead?
It's Thunderdome.
But
Four
to the-
lawyers enter.
Very tough witness to
Fine.
cross-examine.
Cross.
this. Oh, please be
Gotta
B.
relax
Ivory.
for 5 minutes.
Yeah.
They want 5 minutes to look at each other and go, "Oh fuck."
Why?
Why do you need 5 minutes?
Just we do a quick sidebar.
No.
No.
Nice.
Sidebars already.
Number one, our paralegal is locked outside.
Apparently, locked outside because she left because I told people are not coming in and out of this room.
But she was already gone, I think, Judge, when that was ordered by the
Too
court.
bad.
Counsel, use the mic.
Judge, number one, our paralegals outside. There's some.
And counsel, you can handle it. You have 3 people at your counsel table.
You don't need the paralegal.
Some documents.
More than
That,
I normally allow.
Judge, there were some documents that we wanted to have her print out some extra copies of.
Some extra
2
copies of?
minutes.
That's fine.
2 minutes.
Go out, follow my bailiff.
As we talk about compromising a crime scene, now you can confirm your knowledge of a wallet being removed, correct?
Yes.
But you don't know if there was other items, like a weapon, that could have also been removed from that crime scene, correct?
Correct.
You don't know if other item had been moved from one place and put in another place.
Objection, Your Honor, there is absolutely no evidence that anything was moved.
That's right. There's no evidence of that. Don't imply something, counsel, that there is no evidence of. None. There's been
Oh my
no
God.
evidence introduced in this case by any witness that is even close to that. That assumes facts, not in evidence. Sustained. Move on to a relevant question.
You're making
Don't imply things that have not occurred and are not in evidence. Move on.
Judge is so pissed.
To state 83, please, the during video.
When we got down
Look at
to
that
his
face.
intentional use of force, he kind of disavowed it.
Man, I wouldn't want to be the guy
understand
dating
it's
that judge's
some-
daughter.
They're right. It's some evidence, and it can come from anywhere within the case. They can even use evidence from the state's case and in the video. Maybe that's their argument, but at least I think it's.
I think some evidence has been met. I also think there's a negligent as well, if the state's going to say, well, that's what he said, accident, I mean, then there's evidence for that instruction too. And
Well,
the
you're
jury's
getting-
gonna have to consider
Oh yeah, take
5
away
different
self-defense
homicide
and give him
offenses.
negligent
Sure.
homicide.
Yeah.
That'd be
Sure,
great.
Sure, let's get the accident instruction. That'll be good.
Because you would take second-degree intentional homicide off the table, because that only applies with self-defense. And if you want to go from first, if you want to go from first,
He's getting a headache. He's getting a headache.
Strangle one of you.
You say that?
I've got a jury waiting, gentlemen. Mr. Hubner.
I'm willing to allow the negligent, although self-defense wouldn't apply to it under the theory that the defense is trying to get it in this situation. So it has been modified that way.
What a nice
Then
prosecutor.
after I did that,
Use the mic. So can I characterize it as reluctantly stipulating to the instruction on negligent homicide? Fine, because as I said off the record, I was not going to give it. I think the decision in Watkins, which I glanced at yesterday and had a bit more time to review while we were off the record, is a different situation. But if the state's stipulating, fine, I'll give the instruction on negligent homicide. Now I think we've reached a point where literally the jury can consider every form of homicide that exists in the Wisconsin statute. Correct? Am I missing one?
felony murder, you're missing felony murder. I'm not.
Because we've already given 5 of the 6 possible homicide instructions that exist in Wisconsin. I'd like to not set the world record for lengthy jury instructions.
That was a good.
Mott, I hope we're done
It was
discussing.
a good line. I was a good line.
Last issue, placing on the record, states objecting, but I think if we're doing the negligent, then the accident 772 should be given. I know this.
Are you pushing your luck?
772 instruction should be given based on.
Okay, we withdraw our stipulation. Fuck you.
I know the state's objecting to that.
I'm not clear what the point is at this point. It'd be illuminating to listen to the closings, and the jury is the ultimate arbiter. The jury will consider the evidence. The jury will render a verdict. But I'm extremely confused by the point the defense has been trying to make. They tried to make one point for an entire 6 or 7 days. Then their client took the stand and basically changed what was being implied, if not directly argued to the jury. Mr. Edgecomb did everything he could yesterday to say the gun just went off. So I'm not clear what point the defense is making. Maybe we'll find out at the closings.
I doubt it.
By the way, gentlemen, we discussed a lot of this yesterday. We spent 45 minutes on instructions yesterday. It's frustrating when the defense adds all these additional requests on the morning I'm going to instruct the jury. I told the jury to be here between 8:45 and 9. They were all here by 8:45. It is now 10 o'clock. It benefits no one, and it is not fair to a jury to have them sit in the jury room hour upon hour.
We'll see what happens.
Welcome back, ladies and gentlemen. I'm sure over the course of the last week plus, at times you must think, geez, Borowski cannot tell time because I said you'd be around 9 and it's more like 10. We've been discussing a few things, discussing the jury instructions. So I don't expect you to memorize them. You don't have your notepads. You don't need your notepads. There's no way you can memorize them. Rain Man couldn't memorize them. Okay. So we'll get a copy of the instructions when you deliberate. You guys all get the bagels?
Bagels.
Bagel.
You're welcome.
He promised bagels.
It was
You
hard
did
to
promise.
4 in the morning to bake.
Tomorrow they get lunch.
No oil, but it's a sacrifice I was willing to make. I'm driving up to Green Bay. I've got an interview to be the new special teams coach for the Packers. You know, it falls under one of those categories. You know, when you go to a restaurant or you hire an employee, you think, well, or you fire an employee, well, it could always be worse, the next person. But in this case, it can't be worse. It literally cannot be worse.
It's so bitter.
If the judging
So
thing
bitter.
doesn't work, I'm going up to Green Bay Wednesday. Have a good weekend, everybody. Go Packers. We'll see you on Monday at 8:30.
You
Go
learned on.
Packers.
Looks like you all chose wisely and either brought your own lunch or did well in the lunchroom roulette in terms of lunch. So continue. We have a next witness. Who's the state's witness? The state keeps saying that, but yes, our equipment in this building is archaic. It's terrible, pathetic, embarrassing. And that's the best I can say about it.
Gosh, I love this judge. He kills me. It's archaic. It's terrible. It's embarrassing. It's the best I could say about it.
Texting out his reservation about it being
All right,
later
the jury's
today.
back. Sir, if you can stand, raise your right hand.
I need one of those meatball subs immediately when I get out of court today.